Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, courtroom 304. This is the civil calendar for July 2nd, 2025. I'm going to call the calendar, patients on the calendars, but there may be others, and then we'll go forward. Valerie McCullum versus James Alonzo Bradley. That case has been, that motion has been dismissed and the parties were excused. Anyone here on that matter are free to go. Della Infotech Inc. versus Southern Services LLC. Are the parties?
Daniel Hoffey on behalf of Della Infotech, and my client's also logged in as Andrew Fugel, Your Honor.
Judge Wes Dunlap here for Southern Services. I did file an entry of appearance this morning.
Okay. All right. Next is Della Infotech versus Southern Services. So it looks like we have two matters on the calendar. I don't know if it was filed twice. One was filed on April 24th and one was filed on April 25th, or it may be competing motions. So we'll go ahead and hear whatever is outstanding. All right. Next, Devontae Jill Taylor, Denise Tuckenberry versus Michael Corday McKinney. This was rescheduled and heard in June, and all parties were given notice. Is there anyone here on that matter? All right. All right. Jesse Morris versus Jerry Turnipseed and Jerry Pugh. Jesse Morris, Jerry Turnipseed.
Continuance was granted for this, Judge.
Okay. All right. So that continuance on that. And the next matter is Brandon Anderson versus Isaac Pacheco Lopez and Hartford Insurance and U-Haul International. That case settled. Those parties were excused. David Lyle versus Delta Airlines Inc. and Sodexo Magic LLC. Oh, yep, that's still at 10 a.m. Anyone here on behalf of David Lyle versus Delta Airlines? All right. And then Riverdale MHP versus Mortimer and all others. That was the defendant requested a continuance, and Ms. Barksdale was given notice. Ms. Powell?
Yes, ma'am. She was. I'm double checking now.
Okay.
And I did double check on the case that you just called, and there was no outreach about parties not being able to appear. So I'll let you know about the final case on the calendar right now. Yes, notice was sent out on June 19th, and Ms. Barksdale should have received electronic service.
Okay. So Ms. Clark and Mr. Towns, you all are here on which matter?
Robinson versus Pagan, and a motion for summary judgment.
Hmm.
And
Is
Your
that
Honor,
on?
Olson, I'm appearing on behalf of the secondary insurer in this case, which is Progressive Mountain.
Okay, is that on the 11 o'clock, Ms. Powell?
I'm not positive. Can parties give the case number, please?
That case number is 2021 CB 01278.
Okay, yes. That was my error. They were, a Rule 9 was sent, but they were not added to the calendar. So those parties are in the proper place at the proper time.
All right, then we will hear it. All right, so we will start with Della Infotech versus Southern Services.
Okay. But I went on and did it, I got in.
Hello, Mr. Brinkley? Mr. Brinkley? All right. All right, so this is a motion to reopen. Is that correct?
Yes, Your Honor, this was a petition for review of an underlying magistrate court case.
All right. So I'll take it that Della Infotech was petitioner, Southern Services respondent, and Mr. Haley is it? I'm sorry,
Hoffey, Your Honor, Daniel Hoffey.
Progressives. Mr. Hoffey, I'll hear from you, sir.
Okay. First of all, Your Honor, the reason there are two positions on the calendar is I had initially filed that petition for review, as you indicated, I believe on April 24th. But then my client submitted another one on their own the following day, and that generated a second case number. But it's the same case we're here to talk about. And Your Honor, I'll be very brief, and then so Mr. Dunlap can then weigh in. Back in September of 2022, my client was served with a continuing garnishment because they were the employer of the defendant at that time, Mr. Michael Kincaid. My client actually resides, the company's based up in New Jersey, in Princeton, New Jersey. And my client began filing the garnishee answers as required back in November of 2022. They filed approximately 10 continuing garnishee answers while Mr. Kincaid was employed by them. Their final garnishee answer, Your Honor, was filed in January of 2023. At that point, the defendant left the company and was no longer employed there. So my client did file a final garnishee answer at the time they were still holding wages that needed to be submitted to the court. They had been submitting the wage checks to the court. Unfortunately, Your Honor, my client did not file a final garnishee answer informing the parties that Mr. Kincaid was no longer employed by them. A couple months later in a couple months later in March of 2023, Mr. Dunlap's client filed a motion to seek a default judgment against the garnishee as a result of them not filing a final garnishee answer informing the court that he was no longer employed there. A long time goes by and my client did not hear anything. And it appears, Your Honor, that the Clayton County Magistrate Court did not act upon Southern Services' request for over a year. It appears that the Magistrate Court finally signed the Southern Services' request for a default judgment against the garnishee back in June of 2024. My client was served with that garnishee default judgment on, I believe it's July 22nd, 2024. And they immediately contacted the Clayton County Magistrate Court and they electronically, I'm not sure if it was electronically filed, but they submitted an appeal in letter format, Your Honor. It was not actually styled as a motion to open default judgment against the garnishee, but that's basically what it was. And that was.
May I ask one question?
Yes,
so
ma'am.
When Southern Services filed their motion for default, was your client copied on that motion?
I don't know if they were. Mr. Dunlap, can you confirm that one way or another?
I'll check my client's records and see what I have.
While he's doing that, Your Honor, I do also want to add that the clerk's office had inadvertently attached the defendant's address to my client. So in other words, the clerk's office had been sending any notices from the clerk's office to the defendant's address. They were not correctly sending notices to my client's address. That's an issue I'll be talking more about here in a moment.
Okay.
Your Honor, I'm uncertain if the garnishee was served with a motion for judgment against the garnishee. But I can address that when I get a chance to make an argument either
All
way.
right. Go ahead, Mr.
Yes, Your Honor. So upon receiving my client's appeal letter, if you will, the court did in fact schedule on August 5th, 2024, the magistrate court generated hearing notices to all the parties for a hearing to be held on September 17th, 2024. But is as if you look in the magistrate court file, Your Honor, you'll see that the magistrate court clerk's office inadvertently sent both the defendant's notice and the garnishee's notice to the defendant's address here in Jonesboro, rather than sending the notice to my client in Princeton, New Jersey. So, of course, on September 17th, 2024, my client did not appear at the hearing because they had not been properly advised of it. And my client, upon learning this roughly a month later, when they were served with post-judgment interrogatories from Southern Services, my client submitted a second appeal letter to the Clayton County Magistrate Court informing them of their error, that they had not sent notice of the September 2024 hearing. The magistrate court did not act upon that October 2024 appeal letter that my client submitted to the clerk's office. My client submitted another appeal letter in November of 2024. The magistrate court clerk's office did not act upon that either. When they finally contacted me in January of 2025, I had filed a motion to open the default judgment against the garnishee. The magistrate court at that time scheduled a hearing on Southern Services' motion to compel, because while this was going on, my client was indeed served with the post-judgment interrogatories, but they had not responded to them, Your Honor, for full disclosure. They had not submitted the information, so Southern Services had filed a motion to compel. The hearing that took place on March 25th, 2025, that was technically the hearing for Southern Services' motion to compel. However, the judge at that time did go ahead and hear the motion to open default judgment against the garnishee. The motion to open default judgment against the garnishee was denied by the magistrate court. The magistrate court basically said everything was filed too late. So the basis for our petition for review, Your Honor, is we feel that had the magistrate court clerk's office properly notified my client of that September 17th, 2024 hearing, my client obviously would have attended, and this would have been resolved back then. My client was not holding any more wages of the defendant. The defendant had quit by that time. When I filed my motion, I believe on January 31st, 2025, we included a final garnishee answer. So my client just felt that the magistrate court had improperly denied their motion to reopen this because my client had not been properly notified of the September 2024 hearing date, and that my client had submitted the appeal in a timely manner. Granted, it was not technically styled as a motion to open default judgment under 18-424. But that was the reason they did not appear. So that is the basis for the petition for review, Your Honor.
All right. Mr. Dunlap.
Thank you, Your Honor. I'm not sure how much this court deals with garnishments. I know a lot of
I
times.
used to be a magistrate.
Okay. But when a garnishment is served, a garnishee is required to file an answer every 45 days. If they fail to do so, they're automatically in default. And then they have a 15-day window to open that default. And if not, then a judgment should be entered against them. That's OCGA 18-4-21. So as Mr. Coffey explained, the garnishee here did fail to file a final answer. On June the 14th of 2024, the judgment was entered against the garnishee because of its failure to file its final answer. I don't believe any of that's in dispute. It's also not in dispute that the garnishee received proper service of the judgment on July the 22nd of 2024. In Mr. Coffey's motion to open default that he filed, that's the basis of this appeal, he writes that the garnishee did not receive notice of the default judgment against garnishee until July 22nd, 2024. So that date's relevant because under the applicable statute, in order for in other words, the garnishee, if it fails, the garnishment code does allow you to correct your error, but there are specific statutory requirements. Those requirements being that within 90 days, you have to move to modify. And I would agree with Mr. Coffey that the appeal could be deemed that the garnishee was trying to modify the judgment to as allowed under the statute. But there's another requirement that Mr. Coffey didn't mention, and that's the payment of cost. So in the appeal that was filed, and we'll call it a motion to modify, that was filed by the garnishee on July the 24th, there's a couple relevant points. One, costs were not paid. Two, if the court looks at the appeal, there was no request for a hearing. So in the motion to set aside that Mr. Coffey filed in January, where he's trying to undo the judgment that already been entered, he states, quote, "It appears the court sent garnishee's notice of the hearing to the defendant's address. Therefore, the garnishee was not properly advised of the September 17th hearing." I can't see the docket, Your Honor, but we'll take Mr. Coffey at his word that notice was sent to the incorrect address. So Mr. Coffey's argument before the court today is that my client did not satisfy a statutory requirement, but because we didn't have notice of a hearing, this judgment should be set aside. That argument fails for a few reasons. First, this appeal or this motion to modify that was filed by the garnishee does not request a hearing. It's just an appeal. Two, there's no statutory right to a hearing anywhere in the statute. Three, this is analogous to a default claim where the damages are liquidated. As you're aware, Your Honor, under both Magistrate Court Code and the Civil Practice Act, if damages are liquidated, there's to be no hearing. Similarly, under the garnishment statute, OCGA 18-4-21, it establishes with certainty the amount the judgment should be entered for. It says that for the amount remaining due on the judgment obtained against the defendant, as shown in the plaintiff's affidavit, there's no hearing needed to establish what the amount of the judgment should be against the garnishee or for any other matter. Most importantly, costs were not paid, so the trial court was without any discretion or jurisdiction to make any ruling whether there was a hearing or not. The case of Freese versus Mitchell, 318 Georgia Appeal 662, 318 Georgia Appeal 662, it states payment of cost is a condition precedent for opening a default under 91155, and those cases are analogous. It says merely offering to pay cost, as here, is insufficient. When this statutory requirement is not met, the trial court lacks discretion to open the default. So Mr. Coffey's argument appears to be is, yes, my client completely missed the statutory requirement to pay cost, but because we weren't provided notice to a hearing that we neither requested nor were entitled to, I should be given a second bite at the apple. That's not the law. The Court of Appeals has ruled on very similar cases in multiple instances. For example, in Principal Lien Services versus Chimex Boat Rock, 349 Georgia Appeal 511, 2019, the Court of Appeals looked into the issue of a garnishee and the requirement to pay the cost within the 90 days. And it went back through all the cases over the last 40 or 50 years, and the court basically landed on this. It is undisputed that Chimex filed the motion and paid the accrued costs within 90 days, so it goes through. But anyway, it says OCGA 18-4-24 requires both the timely filing of a motion to modify and the payment of accrued cost as statutory prerequisites to modification of the default judgment. A similar case is Maley versus Van Cronkite, 220, Georgia Appeal 21. It's a 1996 case. In this case, it says Specialty Atlanta contends that only the motion to modify must be made within 60 days. It used to be 60 days, as you're aware, Your Honor, while the payment of costs is merely required at some time before the court modified the default judgment. But case law does not support this position. In light of this court's holding that payment of costs is a prerequisite to bringing the motion to modify, Specialty Atlanta's argument that it must pay cost only at some time prior to when judgment is rendered must fail. Anyway, when you read all these cases, there is a statutory requirement that was placed on the garnishee in order to have the judgment modified. No hearing that should or should not have been held or anything relieves the garnishee of its duty. I searched for 2 hours yesterday trying to find a case that supports Mr. Coffey's position that they're let off the hook for meeting this statutory requirement simply because they didn't attend a hearing they weren't entitled to and didn't request. So my position is that the garnishee defaulted. The statute envisions, okay, garnishee, you've messed up. Here, you can follow this procedure. But until that procedure is followed, the court has no jurisdiction to do anything. So I would just ask for the motion to be denied and for the judgment not to be modified, for the judgment to stand. Thank you.
All right, Mr. Hoffey. So the crux of Mr. Dunlap's argument is a hearing is not required, so notice or failure to provide notice is not the gravamen of the issue. It's whether what is required, paying costs, whether that was done and whether that was done timely in order to save your client's appeal. So go ahead. You have to unmute, sir.
Yes, Your Honor, that's correct. The costs were not paid back in 2024. We readily admit that. My client
Mr. Hoffey, you're having to fall on your sword quite a bit for your client.
I understand, but my client just feels that they were wronged by the fact that the court did acknowledge their appeal by setting a hearing, even though they didn't specifically put the magic words in the letter, please give us a hearing. The court did act upon it, but the court sent it to the wrong address. So I understand what Mr. Dunlap is arguing, but that's the basis for our appeal, Your Honor. My client feels that the court was giving them the chance back in 2024 to open this up, but they were not notified. But we acknowledge the costs were not paid back then per the statute.
Okay. All right. So unless there's something else, it seems that it is a simple matter of verifying with the case law that's been provided, which is post my tenure in the magistrate court, and making sure that we are dotting our I's and crossing our T's, but we'll get an order out to you.
Okay. Thank you, Your Honor.
Okay, thank you, Your Honor. May we be excused?
Yes, sir.
Before the parties are excused, I'm sorry. Mr. Dunlap, I see that unless I'm looking at the case that you did not file into, I see that we have a brief and supportive petition for review from petitioner, but we don't have anything from respondent. Do you mind just emailing me some of the case law that you recited so that I have that to pull from, sir?
Yes, and I'll copy Mr. Coffey as well. Can I get your email address?
Yes, sir. KIERRA.POWELL@ClaytonCountyGA.gov. And then, Judge, I assume we're going to dismiss the second case.
We can dismiss or consolidate since it's the same.
Yes, ma'am.
Yeah,
Okay, I'll have that to you, Ms. Powell, here in about 10 minutes.
Thank you.
Okay, thank you, Your Honor.
All right, thank y'all.
Thank you, Your Honor.
Take care. All right, so the next case on the calendar is all right, I think it's the one that I don't have written down with Mr. Towns and Ms. Clark.
Yes, ma'am.
All right. All right. So Ms. Powell, if you just send me the style of the case, go ahead and send me the brief.
Yes, ma'am. Judge, I messaged you the style of the case, and I'll send the rest of the documents over shortly.
All right, thank you. I'm sorry, you said you sent it, Ms. Powell?
Yes, ma'am. I text you the style.
Oh, I'm looking at my email.
Okay.
No
But I'm
problem.
emailing you the documents in a second.
No problem. Thank you. All right, Tony L. Robinson, plaintiff versus Hector Pagan, 2021 CB 01278. All right, Mr. Towns, Ms. Clark. Okay.
Yes, Your Honor.
Oh, okay.
It's our
and
motion.
I'm sorry, Ms. Olson is here on behalf of the UM carrier, is that correct?
So I represent Progressive Mountain Insurance, Your Honor. We are the secondary UM carrier, so we do obviously have an interest in keeping the primary UM carrier in the case.
Okay. All right. Thank you. Go ahead, Ms. Clark. You were speaking.
Yeah, I don't think I'm going to admit that we're the primary UM carrier, but I will say we're UM carrier as well for Georgia Farm Bureau, and we've presented the court with a motion for summary judgment. In our motion, as the court is aware, we have to make a prima facie case to show there's no genuine issue of material fact. There's two issues that we've raised in our brief. One is that the plaintiff failed to provide notice under his contractual obligations, and that he also failed to properly serve us within the statute of limitations. I don't think plaintiff is disputing that we've made that prima facie case. I'll just rely on our brief and the case law cited there. So plaintiff has the burden to produce a genuine issue of material fact with admissible evidence. For both issues that we've raised in our motion, we believe the plaintiff has failed to present any evidence showing that a genuine issue of material fact exists. Instead, he asserts in his pleading that he did not provide notice and that he can serve us properly within the statute of limitations because the statute is told. But for neither assertion is supported by documentation, an affidavit, a sworn statement, or even supporting facts under OCGA 91156E. I think the best way to explain this is through a timeline. I'm sure the court is aware too, Georgia Farm Bureau, like many insurance companies, has a notice requirement in our contract with insured drivers for uninsured motorist insurance that in order to receive uninsured motorist coverage, you must notify us of the accident and when a lawsuit is filed. That policy is included in our exhibits as well as an affidavit from Amanda Cox, who is who's familiar with the records process.
May I ask one question? So you said
Sure.
you are not admitting to being the primary UM carrier. So, and there exists currently two possible UM carriers. Not sure which hierarchy they're in. How does he have two UM carriers? Is there an employer involved? What's going on?
Yes, there is an employer. He has a company that's attached in our exhibits as well. I think it's called First Security or First Choice Security, something like that. And one of the insurance carriers, I think, rides under the company, and one is his personal insurance. And
Okay.
I'm sorry, Judge, I'm not totally familiar
I know
which
you
one's
put a
which.
lot of stuff in your brief, and not that I don't read it, except that the statute requires me to provide you with a hearing for summary judgment motion. So I think we should make a full record. That's just my theory. So if I have a question, I usually ask it.
That's fine, Your Honor. I'm sorry. I'm not totally familiar with the facts about which carrier is primary here, but I didn't want to admit it.
No, I got you. Go ahead.
So, anyway, the notice plaintiff signed a contract for a policy with this notice requirement that went into effect on August 20th of 2019. And that's policy number 3551857. So to backtrack a little bit, plaintiff did have a prior policy with Georgia Farm Bureau from some unknown date until February 2017. At that point, the policy was canceled by Georgia Farm Bureau. The date on that notice is January 1st, 2017, and that policy number is a slightly different policy number, BAP 3211476. That notice is relevant because that's the document, Exhibit A and plaintiff's response is that document that they've provided. Plaintiff then got a new policy with Georgia Farm Bureau on August 20th of 2019. The accident occurred on October 18th of 2019. He filed a lawsuit on June 2nd of 2021. He provided notice to, according to our records, he provided notice on March 14th of 2023. And that's in the affidavit from Amanda Cox, which is Exhibit 8 in our statement of material facts. We were served on July 24th, 2024. He actually served Georgia Farm Bureau Casualty and not Georgia Farm Bureau Mutual, which is another problem that we've alleged in our brief. The only reason we were served and notified of the accident is because his other UM carrier, Progressive, as you've heard, who was timely notified and served, told him that there was an active Georgia Farm Bureau mutual policy. So the notice that we received, he did not provide us notice for more than 3 years following the accident, and he did not notify us that he had filed a lawsuit for almost 2 years following the accident. In plaintiff's response to our request for admissions, which were late, and also his pleading and response in this motion, he says he did notify us at some point after the accident. But there's no affidavit, there's no factual support when, where, how he notified us or who he notified specifically. And in support of that assertion in his pleading, he provided us with this letter of a non-renewal that he says that Georgia Farm Bureau provided to him when he notified them of the accident. But we also don't know how he received that piece of mail. If you look at the piece of mail, it says it was sent on January 5th, I think, of 2017, or January 1st of 2017. It has a different policy number. We don't know how it was returned to him again, according to him, whether it was by mail, by email, by some online portal. We don't have any notification of that, and we don't have anything in our records showing that someone resent him that notice sometime after 2019. And other problems with that document is it's not authenticated, and it's not responsive to generally an insurance company, you make a claim and then they send a letter to you or an email or some kind of documentation saying that, we're rejecting your claim because you don't have coverage. And in this case, this document is not that type of document. It's a non-renewal notice, and it's not responsive to the notifying the insurance company of an accident or making a claim. And it doesn't corroborate plaintiff's assertion that he notified Georgia Farm Bureau. But now if plaintiff had presented some kind of affidavit, for instance, saying how he contacted us, when he contacted us, who he spoke to, any type of facts supporting that assertion, it might be enough. But instead, he's only produced conclusory self-serving statements and a pleading, and that's not enough to meet his burden to show that there's a genuine issue of material fact in this case. With respect to the statute of limitations, plaintiff asserts that he can re-serve us because the statute of limitations is told because the prosecution of the traffic ticket from 2019 is still pending. But again, Your Honor, he has not provided any kind of documentation or evidence showing that the traffic ticket is pending besides a case number I looked up the docket for that case number, Judge. It is in Clayton County, so you may be able to look at it. But that case number is under a different name and it's not on Odyssey, so you can't review the documents. So he just has not presented the actual evidence that we need in order to determine if the statute of limitations is even told. And that's, almost 6 years from the date of the accident, Your Honor. If the
Well,
court doesn't have any
the-
questions.
Whether the traffic case is still pending that's not unbelievable.
No, Your Honor, it's not unbelievable.
But you would have to show proof of that. But yeah, that's not the length of time. We're much to our chagrin, it's not moving as fast as we would have liked post-COVID.
Right, Your Honor. And our contention is just that there's no evidence showing that that's still pending.
All right, Ms. Olson, are you observing, or is there anything that you want to present before we turn it over to Mr. Town?
Yes, Your Honor, I think I'll probably just add on a few details that might be relevant to your consideration. As far as the traffic case, I did actually call the clerk of court quite some time ago and got the case name and was confirmed that it is still pending before Judge Spencer. There's actually a bench warrant out for the defendant's arrest. So I think it's a matter probably of public record that the statute of limitations is told. I don't know that the court would be required to review other evidence beyond the public records. If you'd like the case number, I can provide that to you. But there are multiple counts still pending. So I believe the statute of limitations would be told. As far as the issue as to primary or secondary insurance, Georgia Farm Bureau issued a policy of insurance that was active with Mr. Robinson, the plaintiff, as the named insured. My insured is a company called Force Inc. We do have a policy of insurance on which the vehicle involved was a listed vehicle. Mr. Robinson is not a listed driver, but he was operating the listed vehicle. In our policy, it specifically has a endorsement with an other insurance clause that states the policy, the priority of insurance will be as follows. And first priority is any policy insuring the injured person as the named insured. So pursuant to the contractual terms of our policy, Georgia Farm Bureau's policy would be primary. I have not seen anything in their policy that would suggest that they are secondary. And I think there's clear case law that states that if it's in the terms of the contract and plaintiff has failed to mitigate his damages by availing himself of that available coverage, then we would be entitled to declaratory relief in the form of a limit to our obligation to pay only to sums beyond the combined available coverage from the defendant and from Georgia Farm Bureau, which I believe is $60,000 that Georgia Farm Bureau has here. So obviously, if they are to be dismissed from the case or summary judgment is to be granted, we're going to be in a position then to have to file a DEC action for that credit. And
do you all have a notice requirement?
We do have a notice requirement, and we didn't receive notice till 2023. They were notified 2 weeks after we were. So we both have notice requirements that plaintiff failed to meet. And obviously, if you grant Georgia Farm Bureau's motion for summary judgment on the notice issue, you're going to very quickly receive one from me, basically setting forth the same set of facts that we were not notified by the plaintiff until 2023. Obviously, it's a 2021 lawsuit. So we're going to have multiple issues to address if their motion is granted. It is our position that they do belong in the case. And, you know, we made every attempt to involve them, and were also told that they had no coverage, which is not correct. So, you know, they continued to maintain the position that they did not have an active policy of insurance when they absolutely did. That was relayed to my claims adjuster. It was relayed to me. So obviously we can provide supplemental documentation if the court feels they need it, but we do believe that they are the primary carrier and do need to be in the case.
All right, Mr. Towns.
Good morning, Your Honor. Just listening to the arguments of counsel for Georgia Farm Bureau. Just wanted to make it clear that the court can take judicial notice of the case, the criminal case still being pending in the state court of Clayton County. I believe that we did provide the case number in our responsive pleadings, but just so the court has the case, it is 2019 CR 10598, consistent with the statute, Judge. We do not have to. The statute of limitations is told for a period not to exceed 6 years. Once the 6 years elapses, then the 2-year statute of limitations begins. So I don't think that there is any issue with regards to the statute of limitations against the defendant in this case. If the court takes judicial notice on the criminal case still being pending, 2019 CR
10598.
Yes. Further, Judge, with regards to the notice requirement, we did put in our pleadings that Mr. Robinson contacted Georgia Farm Bureau shortly after the accident to notify them that he was involved in an accident. He was informed at that time that he did not have coverage from that vehicle. At that point, he did not make any additional contact until later when he called to confirm that he still didn't have coverage. Once he received that information, that was the second time that they advised that there was no coverage. Georgia Farm Bureau had even provided him with what we presented as Exhibit A to our response pleading, showing that he had a notice of non-renewal from that 2017 policy. They claimed that his policy ended in 2017. Now, when you contact the insurance company, what they should have done when he contacted and advised that he was involved in a motor vehicle collision, gave his name and gave the particulars of the accident, they should have looked to all policies that could have provided coverage for him. They did not. In fact, counsel for Progressive has already informed the court that their adjuster, as well as her office, contacted Georgia Farm Bureau and they denied that they had coverage at that time to them. I can state in my place, Judge, when I contacted Georgia Farm Bureau, they suggested that they didn't have coverage. So with regards to the notice requirement, unfortunately, we don't have a transcript of a phone call.
Well, let me ask this though. So when you get insurance, so the new policy of insurance that we're talking about, so after the non-renewal, there was a period of time where there was no coverage, and then there was a new policy. Am I on the right? Okay. So when I get a new policy, I got to pay for it. Was there any record of Mr. And the date at which Mr. Robinson paid for insurance with either Georgia Farm Bureau or Progressive Mountain Insurance. I don't think Progressive Mountain Insurance is really the issue with respect to whether insurance exists. But with Georgia Farm Bureau, was there any indication of when he would have initiated that new contract or paid for the insurance through that would have provided coverage?
Judge, I don't have that, but I can get that information as far as the payment of his coverage and when it became effective.
Yeah, because that would have been the first thing I did. If I know that I'm paying premiums and you tell me I don't have coverage, the first thing I'm going to do is, in fact, I had a condo that got wiped off the face of the earth by a tornado. I know you hear that about that on TV. I never thought it would happen to me. But the first thing I did was go to my records to make sure I had paid my insurance for that year. Thank God I did. So that was before I even called them, that was my confirmation that, yeah, I should have something. So was there any indication based on payment records or any other communications that Mr. Robinson had coverage?
Well, Judge, let me, I guess, clarify some of the issues. Mr. Robinson was actually in a vehicle that is owned by his company,
Employed.
Incorporated.
Does he own the company or does somebody else own the company?
He owns the company. So
Okay, so he had separate insurance for himself personally, and then he has insurance for the vehicles covered by the company.
correct.
All right, I'm clear.
The vehicle that was involved in this collision was owned by the company. Obviously, he was involved in the collision. Georgia Farm Bureau, under the old policy, insured the vehicles owned by the company under Force Incorporated. Progressive then insured the vehicle on the date of the collision. What we've learned is that Georgia Farm Bureau also insured Mr. Robinson on the date of the collision for his personal vehicles. When he made the call and they gave the information, he gave the information for the company vehicle and was informed that they do not cover him. That is why I'm suggesting, Judge, that once he made the call, he gave them the information involving the accident, but they determined that he was not covered based upon their internal information. I don't know if they looked to his private insurance, and I was going to suggest that they should have. Once he gave his name and information, they should have then cross-checked to make sure that he is not covered before they gave him the information that he was not covered. Judge, unfortunately, we don't have a transcript of the phone conversation. I suspect that Georgia Farm Bureau may, but obviously they have not presented any information with regards to the assertion that he made the calls to Georgia Farm Bureau. They have the information, as counsel alluded, in responses to discovery, that he made those calls to, or that he contacted Georgia Farm Bureau. They don't have anything disputing that he made those calls. I suspect that they should know, or that they may have had recording of these conversations. But irrespective of that, Judge, once he's informed that he does not have coverage, we don't put Georgia Farm Bureau on notice until there's a dispute between ourselves and Progressive. Progressive says, hey, Georgia Farm Bureau is the primary underinsured carrier. We advise that we've already been informed that there is no coverage. We contact counsel for Progressive, advise that's what we've been informed. We provide her with the same notice of non-renewal that we were provided. And it wasn't until sometime thereafter that Ms. Olson confirmed that, our attorney Olson confirmed that there was, in fact, another policy. Unfortunately, just one of those situations where, quite frankly, I think Georgia Farm Bureau dropped the ball on this.
Okay, so Ms. Clark's argument is based on you not having the, I guess, once the burden is shifted back to you all to produce a genuine issue of material fact for consideration by a jury, she's alleging that you have not provided the court sufficient affidavits or factual information to shift to pass that threshold once the burden shifts back.
Yeah, and I'm prepared to swear Mr. Robinson in and have him testify that he gave Georgia Farm Bureau a call and that they advised him that he was not covered.
Any reason why that wasn't provided in an affidavit to the written documents?
Judge, we provided that information with regards to discovery responses, which would have been the request for admissions, the response to request for admissions. As well, Judge, we had a document that showed that there was a non-renewal. There's no reason for us to present a document or even for them to present a document of non-renewal unless it's in response to some request. As far as I'm concerned, Judge, we presented documents, but I guess if the court needs additional information, we provide that to the court.
All right. I don't have any other questions. Did you have anything else that you needed to tell me?
Judge, I'd like to, I guess, since the question has come in, I guess I need to tender Mr. Robinson's testimony. So I'd like to call him as witness on it. And I'll get logged in right now.
Judge, I'm going to object to him testifying at this point. From my understanding, any oral testimony provided at a motion for summary judgment requires a notice, and we have received no notice, which I think is obvious since he's offering to swear him in now. That case is Orr versus Woodruff Robinson Inc. 142 Georgia App 861. That's a 1977 case, but unless the law has changed, which it doesn't show that in the case, he needs to provide a notice if he's going to do that.
Judge, is she asking for a continuance?
That's not what I heard, Mr. Towns, but y'all can clarify that on the record. One second.
Judge, I'm objecting to him testifying at all. I mean, we've had a notice of this hearing.
I'm clear.
Okay.
I'm sorry, what was that citation again, ma'am? Ms. Clark?
Do you just want the number? 142 Georgia App 861. The style of the case is Orr versus Woodruff-Robinson Inc.
Sorry, counsel, the style of that case again is 142 Georgia App
861.
Essentially, what Ms. Clark is saying is pretty much dicta for the case because the case is basically based on whether there's the availability of a court reporter. But it does say that if the court is to hear oral argument in a motion for summary judgment case, that notice should be given. I think I have all I need to make a decision, so I will get that out to you all.
Thank you, Judge.
Thank you.
Thank you.
Judge, I would just ask if you're going to make a decision based on whether we're the primary UM carrier or not, that we have an opportunity to present testimony or argument about that.
I don't think that's the decision I'm called to make.
I don't think it is either, Your Honor. I just, from hearing Progressive's attorney, I just wanted to make sure you weren't planning on making that argument without letting us.
Yeah, no, I don't. That's not the decision y'all are asking me to make. You're asking me whether you stay in the case or out of the case. That is this decision I feel like is before me. I don't get to decide contractually because that's not before me, whether you're primary and they're secondary. That's contractual, and y'all haven't made that argument fully. Essentially, Progressive has said this is what we believe exists. And I don't know what's in your contract, so I wouldn't be able, I'm not informed enough to make that decision.
Okay, yes, Your Honor, I agree. That's all. I just want to make sure.
Yeah, Ms. Clark, I will bring that matter before the court at a later date. I was simply raising it for purposes of clarification of the impact of the motion for summary judgment.
Okay, great. Thank you. Sorry.
Yeah, I tend not to do more than I'm called upon to do. It makes things simple. All right.
Thank you, Judge. Bye-bye.
Thank you, Your Honor. May we be excused?
You may.
Thank you.
Ms.
Judge,
Powell, yes,
oh,
ma'am.
go ahead. I'm sorry.
I was just going to ask if we have anybody else for the 10 o'clock calendar.
We do not, and I was going to confirm with you that the case number position 7 on the calendar, I actually rescheduled them for August 20th so that they could have ample notice for service. So that's why they did not appear. And then for position 8, Ms. Barksdale representing the landlord and the tenant, do you want to just grant that continuance?
And Ms. Barksdale has been made aware of it, and she's okay with it?
I have not heard from Ms. Barksdale, but since she didn't appear today and the defendant did file into the record the motion for continuance, she should have had notice of that yesterday.
Right. That's fine. We'll continue them to another calendar.
Yes, ma'am. And that completes our 10 o'clock calendar.
All right. So for the 11 o'clock calendar, ladies and gentlemen, good morning. The first case on the calendar is Antoine Jones versus Nakia Brown and State Farm. That case was dismissed with prejudice, so they probably have reached an agreement. The second case is In-Town Suites Management versus Teresa Smith, Anthony Smith, and all others. Anyone here for In-Town Suites?
John Richard here for In-Town.
You gonna give it another swing, Mr. Richard?
Yes.
This one should be fairly simple. It's simply a fault.
All right, Ms. Smith, anybody here on Mr. Smith?
Hello, good morning.
Okay, good morning, Ms. Smith.
Yes.
All right, so one moment, let me finish the calendar call. Alfonso Brinkley versus Omar Rashid.
Matthew Carlton for Mr. Brinkley.
Alfonso Brinkley.
All right.
Good
Anyone
morning,
here?
Your Honor.
Good morning. That's Mr. Rashad.
Yes.
And counsel for Mr. Rashad.
Ma'am, I actually did not, I did not receive any notice of this. I just was informed of this. I didn't receive, I think it's called a NASAI, something of NISI.
Rule NISI.
Yes, and so I didn't receive a letter, and I reached out to my attorney seeking counsel for this issue, and they said they looked into it and they just found the Zoom link, and they said I should just ask for a continuance because I haven't been able to secure counsel or anything about this. I did not receive that. So I literally
Hold on. So you just said you reached out to your attorneys, but then you said you haven't been able to secure counsel. Which is it?
What I mean is,
I have Samuel G. Alderman and Bridges Rowland.
Right. And they were active on the case that we handled before with Mr. Brinkley in the past, but we did not, again, I'm just realizing that this happened because we didn't get, and that case was resolved. And then so then they weren't retained for this part of the process. So I had no idea that this was coming. I
Okay,
just found out.
so this was a review of the case, and a counterclaim. So they're appealing with the decision that you believe was closed, and I think they probably sent notice to your previous counsel.
I don't believe that previous counsel received it because they told me that they didn't receive it. And they told me that when I called and reached out to them, they looked into it and they did digging and they saw that a file of NISI was sent to my address, not to their address, to the
Right,
council.
Miss,
Judge, based on my records, it looks like, well, based on my records, we did not mail service. The system shows that that Mr. Rashed was represented at the time. So my belief would have been that his counsel would have received e-service through Odyssey. If that did not happen, then that was a back-end error, but
That did not happen. They were not given service. And they told me to show
all
up.
right, Mr. Rashad. All
I'm
right.
sorry.
So, does Mr. Rashad have an address on file for notice?
1 second, Your Honor. He does have the address on file, and also just making the note that's still on file is Samuel Alderman and Roland Bridges, or Alderman Samuel and Roland Bridges' representation. But the address on file is 542 Ventura Drive. Oh my God. I shouldn't be saying his address out loud, right? I'm sorry, Mr. Rashed.
I was gonna stop you before you got to the relevant part.
Okay.
Okay, all right. So since notice is the bedrock of due process, well, harkening back to law school, this case is going to be reset for when we can give notice. The most likely calendar is probably going to be in August or September. And then the parties will be back here. We'll still have it by video hearing. And that way, Mr. Rashad, if you are going to get counsel, you have that period of time to do so. And then they need to either substitute for the other individuals who need to probably at this point come off the case, or they need to do an entry on their own.
Your Honor, may I say something?
Sure, Mr. Brinkley. Now, Mr. Brinkley, before you say anything, please understand you're represented by counsel. I know it is frustrating for you to have your case moved to a different time. I am required under the law to give Mr. Rashad proper notice, and we failed to do that. So there's not a lot you can say to me to convince me to not do what I'm doing. And it would probably be better if you spoke through your counsel.
Yeah, Alfonso, we'll talk. All right. Thank you, Judge.
The unfortunate part is a lot of times when you are not an attorney, the rules are frustrating. I get it. But in fairness to all parties, which I'm required to be fair to all parties, I got to make sure that Mr. Rashad has the opportunity for notice and to be prepared for that. Okay. So we will reconvene. Everyone will get notice. We've confirmed that we have a proper address for Mr. Rashad, and we'll send out notice in the mail, or if I don't believe he has e-service, but we'll send out mailed notice for Mr. Rashad to accommodate that. Okay.
Thank you, Judge.
All right. Thank you. Thank you, Mr. Paulson.
Thank you.
All right. All right. Calvary SPV1 LLC versus Denise Bruner versus the credit union.
I'll get out of here.
All right. Anyone here on Calvary? Victor Newmark is who I have listed. Okay. I don't have them. So that case will be dismissed for want of prosecution.
And Judge, just so you have, maybe we talk about it offline, but this is the second time this case has come before you. Both parties did not appear the first time, but this was a Social Security matter. So are we dismissing it finally?
Yes, ma'am.
Okay.
All right. Obiora Mbachu versus Eric Booker. That case has been rescheduled to August. So if anyone is here on the Mbaku and Booker case, That case will be on the court's calendar in August. Yes, sir, in the courtroom.
Good morning, Your Honor, Kwame Thompson for the defendant. I'm here for
Okay,
your
Miss Powell, why was this rescheduled to August?
Pulling it up really quickly, but this was rescheduled because we did not have the order ready to go until late last week. I'm trying to confirm that with the record, and I wanted to make sure that all parties had enough notice to appear. So yes, we filed the Rule Nisi on June 25th, which was last Wednesday. That was only 1 week. But the attorneys may have seen that in the system, there was a scheduled appearance for June or July 2nd, which is today, when you guys were intended to show. However, it was rescheduled and the Rule Nisi reflects that.
Thank you. Thank you,
All
Your Honor.
right, you're welcome. And you all can come in by video if you wish.
Okay, thank you.
You're welcome. So the notice will have that information.
Okay.
All right, thank you.
Thank you, Your Honor.
All right, next is Pamela Hendricks versus Andrea Jones and Atlanta Airlines Terminal, John Doe. XYZ Corporations 1 through 4, ABM Aviation Inc. Anyone here on behalf of those parties?
Yes, Your Honor. Troy Hendrick on behalf of Pamela Hendricks, the plaintiff.
Good morning, Your Honor. Allison Brummett on behalf of Atlanta Airlines Terminal Company, LLC.
And yes, Your Honor, this is Anna O'Donnell on behalf of ABM. I think we're listed as ABM Industries on the Rule Nisi, but we should be ABM Aviation on there, but we're here.
I have ABM Aviation.
Perfect. That's what it should be.
Okay. All right. And the next case is Malfred James Colley versus Gregory Lee Crooks Jr. and Gregory Lee Crooks II. Colley versus Crooks. Anything on that case, Ms. Powell?
No, ma'am. I'll check and update you, but no, it was continued from our last calendar, so parties should have been here and they received notice.
Okay. Keisha Walker versus Christopher Perez.
Good morning, Your Honor. Dantes Mars here on behalf of defendant, Mr. Christopher Perez.
Okay.
Keith Foster on behalf of plaintiff Keisha Walker, Your Honor.
All right, Mr. Foster, it'd be helpful for you to rename yourself. Hold on.
I know, ma'am. I'm sorry, but my computer didn't work and I had to grab the first thing smoking. I apologize.
All right. All right. So Antoine Jones versus Nakia Brown, that was dismissed. Here it is. In-Town Suites Management versus Teresa Smith. This is a dispossessory.
Judge, I'm sorry, before we move forward, with position 7, it does appear that on June 25th, June 23rd, counsel was substituted for plaintiff. So do we continue and send a new notice?
I'm sorry, on which one, number 7?
Yes, ma'am. Plaintiff has new counsel, so the information may not have been.
Yeah, let's if they have new counsel, let's go ahead and resend notice.
Yes, ma'am.
Thank you. All right. Mr. Richard, it's my understanding that this is, you said you're seeking a default in this case?
Seeking the issuance of a writ of possession by default. We're not seeking a money judgment. The complaint was filed April 17th. Personal service was made the same day. Affidavits from our court-appointed process server were filed on the 21st of April. The answer deadline was April the 24th, and there is no answer on file by that date or any other. We filed the application for issuance of a writ of possession on April the 30th and got our Rule Nisi shortly thereafter. So obviously, without the filing of an answer, tenants are in default, and we'd ask that a writ of possession be issued.
All right, and you're seeking writ only. All right, go ahead and present your case, sir.
That's essentially it. The rundown of the dates of service, all of those affidavits are of record as of the 21st of April. There is no answer on file by the statutory deadline of April the 24th, and we ask for issuance of a writ of possession.
Ms. Smith?
Your Honor.
All right, so what Mr. Richard is saying is that they have filed their dispossessory after serving you personally, meaning someone handed papers to you. Then you failed to file an answer. And because you failed to file an answer, they are entitled to have a default judgment, but they're only seeking possession of the property, meaning they're not asking for any money. They just want the court to issue them the right to have the property back.
Okay, ma'am.
All right, so you understand that I can only give you 7 days to leave. My writ of possession, and in this case, because it's a default, it can be.
So, what was I supposed to answer? I don't know. I ain't never been to court, so.
Okay, so Ms. Smith?
Yes.
Yes, ma'am. So the documents they gave you should have instructed you that you needed to answer within a certain period of time. You did not answer.
I came down to the court and answered.
You came down to Clayton County,
Yes, Your Honor.
to the clerk's office.
Yes.
Miss Powell, verify that we don't have an answer that Mr. Richard didn't see.
Yes, ma'am. I also don't see one. I'm in that case now.
Okay, Ms. Smith, when you said you filed an answer, what did you do?
I came down here. I gave her the paper that I was served.
Okay, okay.
She have no paper, no nothing. So I wrote it down on a piece of paper and gave it to her so she could show it to you what was going on. So,
what date was that?
The 24th. Let me see. 24th or the 21st. I don't remember. I left my paper. I left my pocketbook at home because I just got off work.
You came to what floor in this building to file your answer?
Downstairs.
Okay, you're on the 3rd floor. So what floor was that?
The bottom floor.
And you said you handed them, so you stood there in the office and wrote out an answer?
Yes, it's like a window. She came to the window. I gave her the paper that I was served. And she said that I want to write something down. She didn't have nothing like, so she gave me a piece of paper and I wrote something down and gave it to her.
I've opened all of the filings just to make sure it wasn't marked incorrectly, Judge, and it's not in the system.
Okay.
She said so that you can see what's going on, my answer.
Do you know, okay, describe the person that was at the window when you talked to them.
I don't even remember.
Black, white, Hispanic, male, female?
White.
I'm sorry?
I think she was white, but she was a female. It was like at 4, it was about to close. It was about like 4, something, 4, almost 4 o'clock when I came.
And you said that this was on April 21st that you went, or April 24th?
24th. 24th, I think. 21st. April 21st. April. When did I answer this? April. '21st. It says right here, May 21st. I don't know. Sorry.
What date did you say again?
I said, on this paper, it says May 21st, but
Okay, that works. Then I understand now. All right, so ma'am, sorry, give me that. You did, okay, listen to me carefully. You took the right steps, but it was not timely. A dispossessory has a 7-day drop dead date, meaning whereas with other cases, you might have 30 days to respond. For a dispossessory, you have 7. You didn't respond until almost a month later. So if he served you in April, you would have had to file your answer 7 days within 7 days after you were served. So after you were handed the paperwork, you would have had 7 days.
excuse me, this was when they gave me, when I got this paper, it says, oh God, I can't see. So ordered this 21st day of May. I guess this is when I got the paper. I don't know, I got some, I'm sorry.
Your Honor, I think what she's referring to is the rule nisi, which is dated the 21st of May and was filed in on May the 27th.
Yeah, so is my signature at the bottom of that paper you're looking at, ma'am?
Yes.
Okay, yeah, no, that's not the summons and complaint. So essentially you just filed it on the wrong date.
I know I did it the 7th day, I did it on that 7th day, but anyway, I'm tired. God's good. This
Okay. All right. So, Mr. Richard, so I'll grant the default. Ms. Smith, unfortunately, that means that the default is granted as of today. So you need to get your things, and vacate the property as soon as possible. While it does take some time for, an eviction to take place, you don't want to not have the opportunity to get all of your things, and head to someplace else, before an eviction is put in place.
okay, no problems, no problems. Thank you, sir, for being patient.
All right. And Miss Smith, whenever somebody hands you something from a court, please make sure that you read it carefully so that you know what your timing is. And if you're not able to understand it, because some of this stuff is pretty technical, take it to somebody who can explain it to you, okay?
Okay, I never been through this, so I
I got you.
now. I got it.
If you have a lawyer or a paralegal or anybody at your church or any place that you know of that might be able to explain it to you, ask them to do so, okay?
Okay.
All right, ma'am. Thank you.
Have a good day.
And
You too.
Your Honor, will your office prepare the writ or would you like me to submit one?
You can submit one.
By email or by filing?
If you use the form, it's usually part of the form document. But if you drafted it yourself, go ahead and do the writ and just make it the writ of possession granted instant.
Will do. Thank you very much.
Okay,
May I be excused?
what
Yes.
date is that I have to leave out?
Well, ma'am, it'll be granted as of today. I don't know how long it takes to effect an eviction, but I would suggest you kind of get your ducks in a row today.
Okay, thank you, and I will
All
have
right.
clean
Thank
for you too. Thank you so much.
Okay, take care.
All right, bye-bye.
Thank you.
All right. All right, Pamela Hendricks versus Andrea Jones and Atlanta Airlines Terminal, John Doe, XYZ Corporations 1 through 4, ABM Aviation Inc. So Mr. Hendricks.
Good morning, Your Honor. Troy
Good
Hendricks for the plaintiff, Pamela Hendricks. This is there's a motion to dismiss and there's a motion for the entry of a default judgment, and they're interrelated. The global issue turns on one single issue, and that's kind of whether a service on a supervisor at AATC's registered office is valid under Georgia law. And since this is AATC's motion to dismiss that we are here to oppose, and if Your Honor denies the motion to dismiss, then the court should rule on our pending motion for entry of a default judgment. And because this is AATC's motion to dismiss for lack of personal jurisdiction, based on that issue of service on a supervisor at the registered office, they bear the burden of proof, which means they must not only go first, I think, in this hearing, but they must meet a very high evidentiary standard to rebut a presumptively valid return of service. So, with that.
Okay, who's arguing on behalf of ATC?
Good morning. Good morning, Your Honor. This is Allison Brummett on behalf of AATC.
All right, ma'am, let's hear it.
Okay, so I think that this issue really turns on the fact that Miss
You froze for me for a second. Miss Brummett, if you'll go back to
now?
Yeah, we hear you better. If you'll go back to the top of that and start again for me.
Sorry about that. Okay, so this case actually turns on the fact that the individual who received the papers by the sheriff was not a supervisor of AATC. She was a supervisor of operations, but that is legally distinct from one who is a supervisor or manager of a corporation. So she oversaw some individuals, but she is not a supervisor or a manager as that term is identified in Georgia case law. And so, and Your Honor, we have submitted 2 affidavits, one of Miss Sandra Puckett, who is the individual who received the papers from the sheriff, or rather sheriff's deputy, who came to AATC's office on a Saturday. So the individuals who actually were authorized to accept service of process on behalf of AATC were not in the office on that day. We've also submitted the affidavit of Brian Reiter, who is the vice president of operations for Atlanta Airlines Terminal Company, who has also sworn under oath that Ms. Puckett was not authorized to accept service of process upon AATC. And I don't know if Your Honor has had a chance to read. I know there's lots of briefing in this case, and they're all somewhat interrelated here. So, of course, I don't want to kind of reread anybody's briefs, but I would like to point out several of the cases that I think are instructive in this to the parties' arguments. Because of course, we do agree that we do bear the burden of proving that service was improper, but I would also note that because we have carried our burden, the burden shifts back to the plaintiff to establish that service was proper. So once we've carried our burden of, showing that service was improper, the burden does actually shift back to the plaintiff. And in this case, the plaintiff has submitted no additional evidence to refute the affidavits that have been presented by AATC, by Mr. Reiter, and by Ms. Puckett.
All right, let me ask a question.
Of
Is
course.
there a registered agent for this company?
Yes, Your Honor, there is.
Okay.
Okay. The registered agent is, I believe at the time it was Kim Green. So several of the cases indicate that employees who are not in a position of sufficient supervisory or managerial responsibility within the corporation are not authorized to accept service on behalf of a corporation. So that indicates that just because somebody is identified as a quote unquote supervisor, there is a threshold of supervisory or managerial responsibility that is required. And in this case, Ms. Puckett does not and did not have the supervisory authority in order to accept service of process on behalf of AATC. And again, where a corporate defendant has presented evidence that the person who received quote unquote service of process was not its corporate agent. And in this case, that is very clear. Ms. Puckett is not the registered agent. She was not listed as the registered agent for AATC. And she also was not authorized to accept service of process on behalf of the company. And so in that scenario, the trial court would be correct in finding that the defendant has not been properly served.
Ms. Brummett, so of course the counter argument is always apparent authority and who has the greater weight of knowledge when it comes to service. So in this case, what refutes the argument of someone present who has the title of supervisor or manager who from the standpoint of a person serving would have had apparent authority.
Right. So there's a case in Georgia from 1990. It is Due West Associates versus Renfro Men and Grading Co. Inc. That case site is 194 Georgia App 397. In that case, the process server prepared an affidavit stating that he was told by some individual at the company that he was an officer of the corporation and could accept service of the complaint. But later, that individual prepared an affidavit, executed an affidavit stating that he was actually not an officer of the corporation and could not accept service of process. He specifically stated that he was not authorized to accept service in his affidavit, and this affidavit was never opposed by any admissible evidence to the contrary. And so the court was unable to find that this person was an actual agent of the defendant. And in that case, the court explained, the Court of Appeals stated that the law requires service upon such person if the registered agent is not served or substitute service is not utilized. The court ultimately reversed an entry of default judgment in that case. So even where the process server vouched in their affidavit that the person receiving service as to the company stated to that process server that he was an officer and could accept service, that service was found by the Court of Appeals to be improper. In this case, Ms. Puckett never represented that she was authorized to accept service of process. She never told the sheriff's deputy that she was authorized to accept service of process. She did not tell him that she was planning to accept service of process. So she never actually, like, this is even different from the Due West case where the individual, I guess for some odd reason, decided to lie to the process server. I'm not really sure what the scenario was because they later, presented an affidavit saying that they were not an officer of the company. But here, this was actually completely different because she never indicated to the individual who appeared at the office in uniform, this sheriff's deputy, presumably, that she was the registered agent. And so that, while I understand that, this is one of those things where Miss Puckett never did represent to anyone that she was the registered agent. She never told anybody that she was authorized to accept service. And so for that reason, service of process was not proper. And just because a defendant receives actual notice of a lawsuit, I mean, I think it's been made pretty clear in case law for many, many years, decades, that, as you mentioned earlier today, service of process is the cornerstone of due process. Just because somebody has actual notice of a lawsuit against them does not mean that there has been proper service. That's not the same thing. These, service of process statutes are required to be strictly followed. And in this case, that did not occur. Sorry, I'm in the midst of a cold, so I apologize for coughing and routinely clearing my throat.
All right. Did you have anything else?
I was trying to find, there was one case that I wanted to point out to Your Honor, and I know you were able to review the briefs, but there was one in particular that I wanted to point out to you if I can locate it. I think, in Kennedy versus Southeastern Newspapers Corporation, which is the case that is 2000 Westlaw 441-74135, which is a 2000 case. The sheriff's entry of service indicated that service was to be made upon a managing editor of the newspaper, but it was service was attempted to be made instead on an employee who was erroneously referenced in that entry of service as an officer of the corporation. This was an employee who was the employment manager. Their duties included receiving and screening applicants, but they were not a supervisor or an officer, and did not occupy a position of supervisory or managerial responsibility. And in that case, the court determined that service of process was actually ineffective, even though that individual was, their title mentioned something about being a supervisor. He was, or excuse me, a manager. They were identified as an employment manager, but they were not a manager or a supervisor of the corporation. And that is the difference. Is just because somebody, manages certain people within a corporation, that does not make them a manager of the corporation for purposes of service of process. And in this case, Ms. Puckett was not a manager or officer or supervisor of AATC, nor was she the registered agent. And so for that reason, there's been no proper service of process upon AATC in this case.
To your knowledge, was there ever any other attempts made to serve at the location?
Not to my knowledge, Your Honor, no.
Okay. All right. Anything else on behalf of the defendant's argument?
I believe that's it. I think our briefing is very detailed and covers really all of our bases here. So I think I would leave it at that, Your Honor. Thank you very much.
You're welcome. All right, Mr. Hendrick.
Yes, Your Honor, thank you. So this situation presents what the defendant AATC is asking for is such a huge sort of loophole in the standard rule that it would swallow the entire rule. Because if a defendant is allowed to come in and say that the plaintiff properly gave the paperwork to the Clayton Sheriff's Office, the Clayton Sheriff's Office properly went to the registered agent's correct address, and then once there, asked for someone who could accept the service of process, and then an employee of the Atlanta Airline Terminal Corporation comes out and gives him a business card which says supervisor on it. And then all of those things take place. And then after the fact, the defendant comes in and presents an affidavit, which is, I can't speak to the truth of it other than to say that it's clearly self-serving, because it's in the defendant's interest for that individual, the supervisor, Sandra Puckett, who received the service process, and then to say, just to file an affidavit saying, well, I don't have any supervisory capacity. I mean, that's
so, Mr. Hendrick, let me ask a couple of questions. So I used to do civil practice, so it's been a minute. Things have changed, but what hasn't changed is that people who are serving plaintiffs tend to not want to rely upon somebody who can't do it the right way, which is why I get so many requests for appointment of service of process or a process server, because they want to make sure that that person is going to know exactly who to serve. So you have a registered agent.
Yes.
You can serve the individuals at the location, but when the case is basically depends on whether the sheriff's deputy, who doesn't know anything about civil law, is told to go and serve papers at a corporation where there are multiple people, as opposed to, I'm going to serve an individual. This is their residence. Whoever of sufficient age who resides in that location can accept service for them notoriously. That is, or you can, the person who is, of sufficient age and ability who resides there. So you can serve them personally. You can serve them notoriously. It's not a whole lot to serve an individual with the sheriff's deputy works fine. When you are talking about resting your case on a sheriff's deputy going into a corporation, even on a Saturday, and on a Saturday it seems strange, because there could have been nobody there, but there was somebody there, and they asked for a supervisor, the person who says, or my title says supervisor, and then they hand them the paperwork, and they said, oh, okay. They're not going to necessarily give it back to somebody in uniform with a gun on their hip and say, I'm not taking this. So your whole case on rests upon whether a third party who has no civil training did it right.
Okay. Well, in response to that, I mean, number one, I think that the Clayton Sheriff's Deputy, just like most marshals and deputies' office, I'm sure they have some training. I don't think it's no training, but even if the sheriff may not completely understand the legal hair splitting that goes on in hearings like this, we should be able to fall back on the law. And the law is very clear. And the law says that when an appropriate service agent takes process to a corporation or an individual, serves it on someone with, as Your Honor pointed out in Ms. Brummett's argument, with apparent authority, someone who, whether she communicated, the evidence that's been submitted in the briefings doesn't say that she said anything, but it does state very clearly that she handed them a card with her supervisor title on it. And so that is prima facie service. And
that's Ms. Brummett's argument. So she says, if you've established prima facie service, the burden shifts to them to deny that this was correct.
Yes.
That to deny that service was effectuated. So in that case, they said we have two affidavits that say, A, she didn't have apparent authority to accept service. She never indicated that she did. She may have told what her title was, but she never said, I'm the person, I'm your guy. Then the other person goes further to substantiate the fact that she was not the proper person to serve. So at that point, the burden shifts again to you now saying, I have evidence better than two affidavits and support for that evidence that I served the right person. What is at the point now, is that your threshold? What is your evidence that you served the right person after we've had two affidavits say you did?
Okay, so first I would respectfully disagree that threshold's been met, because it's a very high threshold, and that is supported by the case law as well. It's higher than the standard of clear and convincing evidence, in fact. And that case law is Cosby v. Lewis, 308 Georgia Appeals 668. That's a 2011 case. It is it's amplified later in 2022 in Youd v. Beskin. That's Youd v. Beskin, Beskin. And that's 364 Georgia Appeals 333. And that's a 2022 case. So, and I'm going to quote from that case, and that quote is that the process server's return of service can only be set aside upon evidence which is not only clear and convincing, but the strongest of which the nature of the case will admit. So submitting an affidavit from inside the corporation that stands to gain from this setting aside of the process that was served is not the strongest of which the nature of the case will admit. A deposition, where perhaps the defendant AATC calls the officer to the Clayton County Sheriff's Marshal to testify as to exactly what was said. That would at least be a disinterested third party, and it's not our burden to present that strongest evidence to the court. It is AATC's burden to present that evidence. And it only becomes our burden, as Your Honor correctly stated, I believe that's absolutely the law, that if they meet their clear and convincing, strongest of which the nature of the case will admit. That's the same language from Cosby v. Lewis, the other case that I gave you. And so, we stand strongly by the fact that when somebody, especially, this is the Atlanta Airlines Terminal Corporation. I don't know their hours, but, it's a large airport, obviously. And, a sheriff, a marshal should have no problems going to such an office and asking for a supervisor to deliver service of process to, especially when that office is the registered agent. So if you're open and you're the registered agent and you contact a supervisor, I mean, these are all by implication things that happened. There's no really way to argue that they didn't happen that way, because we know what the sheriff presented when he filed his return of service. So to the extent that we have to prove anything to rebut AATC's self-serving statements, again, I don't comment on the truth of them, but they certainly have some bearing on the credibility of the evidence which is presented to the court in terms of whether it's the strongest of which the nature of the case will permit. I mean, I know clear and convincing evidence is below reasonable doubt for a criminal case, but I don't, somewhere in between. That's when clear and convincing evidence is the standard for taking a child away from a family member. It's very difficult. I believe it should be very difficult for the court to give credibility to someone who files an answer late, that they're allowed to do so simply because service wasn't proper.
So question, so the sheriff's deputy files an affidavit outlining essentially their process of serving the individual who served in this case. And they file the affidavit in the case. And
yes,
like you said, they're a disinterested party. So you think it would have been the strongest evidence that the nature of the case will admit for then the AATC to depose that sheriff's deputy and re-examine their statements when they've already given an affidavit of service that says what happened?
Well, the affidavit of service says what happened, and what is in the affidavit of service is that he served this paperwork on a supervisor. I mean, this is the terminology that's used, and that's exactly the terminology he's required to meet under 911-4. So,
Okay.
And it's a managing agent or someone with supervisory authority. And that doesn't mean, and the case law is very clear that doesn't mean someone who has the ability to contract for the corporation or somebody who has the ability to hire and fire for the corporation. It's just simply someone who the service provider should be able to tell or should be able to presume that that person has the wherewithal to put that service in the right process, in the right channels. So, when you go to, if you're serving the corporation and they have a different registered agent, I think I would probably agree with Ms. Brummett, but you're going to the agent, the address of the registered agent, and you're asking for someone who presents themselves as a supervisor. And you can communicate in many ways. Handing someone a business card that says you're the supervisor of the operations and control center certainly meets the prima facie requirements that sheriff's deputy needs to meet in order to carry out his duty. And then filing that return of service, I mean, this is a very sort of common part of the process of getting a lawsuit started and getting everyone on notice. And to at this point allow the defendant AATC to basically be dismissed from the case is a very harsh punishment to the plaintiff who has followed the law. Now, I would say that if Your Honor sees fit to believe that this service was not proper based on these affidavits, then Your Honor should simply exercise her discretion to allow default to be opened and for the case to carry on without the motion for default, right? Without granting the motion for default. But to to dismiss the defendant AATC based on what, for all other intents and purposes, appears to be what is by the law prima facie service of process, is incredibly harsh to the plaintiff. I mean, I certainly, obviously, our next move, because we always there's no reason for the plaintiff not to presume that we have met the burdens that we need to meet for service of process under these circumstances. The next move for the plaintiff is to move to serve the defendant AATC again, but it would be out of time. So we would, but obviously there would be notice that would relate back to a certain point. Obviously, all of these things, once Ms. Brummett's law firm got involved in the case, it's inarguable that they didn't have notice of a pending lawsuit and that sort of thing. But yeah, that would be an incredibly harsh result for the plaintiff under the circumstances. I mean, you give this information to the sheriff, the sheriff delivers it to the headquarters of what appears to be a large corporation. It has over 100 employees. We've briefed all of this. It's in our all of this is in our briefings with the court and on the record. The affidavit of the sheriff has been filed stating that he was handed a business card by someone who was called out from the back of this corporation, presumably by some, these other cases that are cited by the defendant, AATC, were either a receptionist or there was no valid return of service. These statements regarding one's authority, again, it's as Your Honor pointed out, it's apparent authority, and the plaintiff should certainly be able to rely on that. I mean, this would open the door for defendants to come in after the fact and routinely just file affidavits from within their own corporation saying that, look, we know that the person came out and said, hey, I'm a manager, or the person came out and presented a document like a business card that said, hey, I'm a supervisor, but in reality, they're not. And so you didn't serve us, and so we're not served, and so it's past the statute of limitations, and so now you just can't. I mean, that's all you would have to do as a defendant under this situation, in this scenario, in order to avoid lawsuits altogether. And the law certainly isn't tailored to create a result like that. And so, the like I say, defendant should probably be real careful about who they has to come out and accept papers from a uniformed officer and give them a business card that says supervisor. I mean, that's not
But Mr. Hendrick, if I'm working on a Saturday and somebody comes through the door in a uniform and I know I'm not the supervisor, and essentially what it sounds like is she was the director of the call center. I may be wrong, but that's what that fancy title says to me. And they're working on a Saturday. They're going to call the person who is higher on the totem pole than them, but that doesn't necessarily mean she's C-suite. So I'm just saying they presented affidavits, and their argument is they've shifted the burden now to you now establishing that y'all served the correct person after they've given you information that you have not. You're saying they haven't given me sufficient evidence to shift the burden. And they're saying the ball's in your court now to counter what they've provided.
Right. And I
I'm
understand that.
understanding this correctly, right?
I mean, I think you are, Judge. I do. And I again submit to you that there are many options um, that would uh, uh, that would be better to meet the threshold of the strongest evidence of which the nature of the case will admit. I mean, it's
And they
obvious.
could argue there are many options that would have been better than having a sheriff's deputy serve a company on a Saturday and the first supervisor that walked to the front hand them the paperwork and say, hey, you're a supervisor, take this.
Well, I think that that argument should fall on deaf ears because it's the law. And if you follow the law, then you should not be punished for that. So I mean, even if a private process server, which is obviously another option, but even if you contact a private process servers hands the paperwork to someone that is called out and says, look, I've got a lawsuit. I need to hand this to somebody that has supervisory or managerial authority. And someone comes out and gives a business card that says they're a supervisor. You hand them the documentation. That I don't understand how a private process server wouldn't be able to rely on that as well. I mean, any type of supervisor should be able to pass the paperwork along to the right person, or else they shouldn't be coming out and accepting that type of paperwork, especially at an address that is the address that's the same as the registered agent. Now, sometimes we see registered agents where it's a different office or a different address. And other times in corporate situations, we see an address that is the same as the corporate headquarters. So, I mean, these are not business decisions that I can have anything to do with because I'm not the corporate entity that we're trying to serve. But, these are the risks that you run if you are open on a Saturday and you have someone that accepts paperwork from the sheriff that presents themselves as the supervisor. Of what? It doesn't matter. That's the apparent authority issue. It is not required that the supervisor be the contracting agent for the headquarters or anything else. It's simply someone that has the apparent authority to place important paperwork into the proper channels for a corporation. I mean, this is just the law. And to not do that is the consequences of that should fall on the defendant, and they certainly shouldn't fall on the plaintiff. But if they don't fall on the defendant, then again, the middle ground here is, because what we're dealing with is a motion to dismiss, which was filed in response to a motion for a default judgment. Because the plaintiff filed the lawsuit, waited the proper period of time, no answer was filed, and the plaintiff filed a motion for entry of default judgment, sort of run-of-the-mill type civil practice. And then after that, what you have is a motion to dismiss that gets filed with these self-serving affidavits. And that's all it is. Again, I don't call into question any of the truth of what they're claiming, but it just doesn't meet the standard that is beyond clear and convincing, somewhere above that it's the strongest of that the nature of the case will admit. And for obvious reasons, because you don't want to punish a plaintiff for doing basically run-of-the-mill work and doing it properly, checking all the boxes. So, there's no responsibility beyond that, and unless and until these threshold burdens are met, which we argue are not. But having said all of that, again, the next issue after the motion to dismiss is decided is whether the motion for entry of default judgment should be granted. And it's only an issue that comes into play if Your Honor decides that the motion to dismiss should not be granted. So it's our argument here that that Your Honor has the discretionary authority to open the case for the filing of a proper answer. And it would be out of time, but it wouldn't matter if Your Honor has that discretion to allow that answer. So you know, if there's a middle ground, that's what it is. And I just want to point that out to Your Honor. I think that we would probably end up going through some more filings and briefings if that were the case, because if Your Honor finds that the motion to dismiss is to be granted, then either AATC is going to accept service, or we're going to have to go perfect new service out of time. So, you know, we have these sort of downstream issues that are obviously very contingent upon what you're being asked to decide here today. But it's very similar to the case that Your Honor just heard with the pro se defendant. I mean, when you meet these certain requirements, you know, the law says you got to answer. This is a sophisticated corporation with a lot of employees. And, you know, I've never been to 6,000 North Terminal Boulevard, what the address is for the AATC headquarters, but those are business issues that they need to sort out. When the sheriff comes to the registered agent, Saturday or not, you know, I mean, there's been no evidence introduced in this case that they're not working full bore on Saturdays and Sundays. Maybe they are, you know. So I don't like to go say, you know, liken it to Saturdays for you and I, or Ms. Brumman or Ms. O'Donnell. It may very well be something completely different than that. I certainly know the airport's very busy on Saturdays and Sundays. So I don't want misplaced weight to be put on that particular factor at all. It's just a situation where an officer did his job, a marshal did his job. Sorry, I think it's a deputy. I get them, some, you know, different counties, different, but I think it's a Clayton County Sheriff's deputy. But there's a civil process division. I think you were trying to speak, Judge, but you're on.
We don't have marshals. We have deputies, but yeah, I get it. They have a division that goes out and does that.
Sure, it's a civil process division. They know they know the bare minimums of what they're doing. And that's why the law says that the return of service to a supervisor is prima facie evidence of service. And I mean,
I get that, Mr. Hendricks. That's not, but the argument you keep making is the difference is that Ms. Burnett says, yeah, that's prima facie. She agrees with you. That's prima facie evidence of service, but we've done enough, she says, to count that and shift the burden back to you to show how service upon this supervisor for operations and whatever the center is was sufficient to put the corporation on notice of the lawsuit. So I get it. You're saying that prima facie evidence was sufficient. They said we presented more evidence that it wasn't. And you're saying their evidence wasn't the best that could have been prevented to shift the burden back, presented. And that I have the ability, per my discretion, to call an audible and not grant any of this stuff and just leave it open for them to answer and then participate in the lawsuit because I feel like they were served and they got notice, but the timing issues were weird.
I mean, yes, I agree. I would just add, I would just add one thing, and that, you know, that there's maybe been this insinuation I've heard that there is a supervisor of a call center. This is the business card literally says supervisor of operations. You know, this is not something.
No, Mr. Hendrick, but I've been doing this long enough to speak a little corporate speak.
Yeah, well, corporate speak, you know, it's corporate speak until it matters in a legal setting.
I get that.
If I may, can I clarify?
I could be wrong. I'm really just punting at this point. I could be wrong about what her title means.
Her title is the supervisor of the operations center, not supervisor of operations. That's a pretty big difference.
That was the way I took it. But like I said, I'm not the one making the service, and supervisor was front center. All right, so we will get you all in order.
Your Honor, if I may, can I make a couple of counterpoints?
Sure.
Okay, because I think that there's been some mischaracterization of what the law actually says, and there's a lot of, you know, Georgia case law is very strong, and Georgia case law is very strong, but there's no citations that are actually supporting that. The reality is that, and I did find that citation that I was looking for earlier, it's Hedrick versus Fordham, Headrick v. Fordham, Fordham, 154 Georgia App 415. Service of process on merely an apparent agent is not sufficient. It must be made on the actual agent. I don't think it can get any clearer than that. Another counterpoint is that the office of a registered agent is not a registered agent. There is a person's name who is identified as the registered agent. So it is not sufficient to go and serve it on anybody who comes to the door at the office of the registered agent. There is a person's name identified for a reason.
Well,
we can't have filed a late answer because service was not perfected. So trying to say that we are, my client is less trustworthy because we're filing a late answer, that's just an absurd argument. Service was not perfected here. I'm not sure what stronger evidence there is than sworn testimony by two different individuals. An affidavit is just as strong as just as much sworn testimony as deposition testimony, as testimony in front of your honor. It is sworn testimony. The sheriff's deputy, there is no evidence whatsoever that when he came to the office of AATC on that day, that he said, hey guys, I have service of process here. I have a complaint and a summons. I need to serve it on somebody who can accept this. That is not, and I can tell you from personal experience, and I am an officer of this court, and if I need to be sworn in, I will, that when a sheriff
in the bar, once you take the oath,
exactly, that's
bar,
and I
am able to rely upon your candor with the tribunal.
Okay, so and I will tell you that we had a case where a sheriff's deputy came to my office and said, I need to drop something off with Nicole Stout. And I am a lawyer, so I knew what he was trying to do, but he certainly did not say that he needed to serve somebody. He did not use that word. He did not say service of process. He did not say a lawsuit. He said nothing. He said, I need to drop off some papers with Nicole. Is she here? That was it. I'm a lawyer, so I knew what he was doing. But these people who are, she was just called up. There's a receptionist at AATC who says, hey, can somebody come up? There's a police officer here. And, there's no evidence that, we can't rely on counsel's assumptions here. That's just not enough. There's no evidence that the sheriff's deputy said what he was trying to drop off or what those papers were. The evidence that we do have is Miss Puckett's sworn testimony that he dropped off some papers with her. He just gave her some paperwork and asked for her name. That was it. He said, I got some papers for you. What's your name? That was it. That's what the evidence in this case shows. So another thing, counsel is requesting that your honor, allow default to be opened and let them serve us. Respectfully, your honor, they've been on notice for these briefs were filed over 2 years ago. They have been well aware of this issue and have done nothing to fix it. And it is very clear, it's basic civil procedure that actual notice of a lawsuit is not sufficient for service of process and to confer personal jurisdiction over a defendant by the courts of Georgia. That is literally one of the most basic tenets of civil procedure. Actual notice is not sufficient. You have to strictly comply with the service of process statute. You can't just say, hey, by the way, I filed a lawsuit against you and suddenly there's personal jurisdiction. It does not work like that. So plaintiff has failed to strictly comply with the service requirements under Georgia law. And for that reason, there is no default and there is no personal jurisdiction over AATC. And for that reason, AATC should be dismissed from this lawsuit.
Yeah, one thing I want to just make sure to clarify the Headrick v. Fordham case, that the holding of that case is that if an employee is not an officer or has not been expressly designated by the corporation to receive service, it is necessary that he or she occupy some position of managerial or supervisory responsibility within the organization.
And again, the case specifically says that apparent authority is not enough.
I know, I can read. And
Okay,
I've already
well-
probably read a ton of these cases because y'all aren't the only case where apparent authority is the subject of the motions. So it's just like premises liability. Some things don't change. They may update it, but even since I was filing stuff, that it's pretty much the same argument. I just have to look at the nuances of what you are saying to make the decision, and I will.
Thank
All
you.
right.
And then that is all very well briefed in the exhibits that we have filed. Both sides have filed their exhibits, and we would rely on those. I know that Ms. Brummett does as well.
Absolutely.
All right. Thank you. We will get you an order out pretty quickly.
Thank
Much
you very
more
much.
quickly
Judge.
than you got the hearing, and we apologize for that. Things weren't going well a little while ago.
All right.
Thank you very much, Judge. Maybe
All
we'll be
right.
excused.
Yes,
Thank you all. Have a good afternoon.
you too.
Thank you.
All right, and I believe this is our last case coming up for the electrified calendar. Sorry. When I go looking stuff up, I mess up my, I lose my place on my email.
Judge, we should
All
be
right.
on Keisha Walker versus Christopher Perez now.
Yeah, that's the one I have. All right, so Keisha Walker versus Christopher Perez. We have Keith Foster for Ms. Walker and Dantes Mars for Mr. Perez.
Yes, Your Honor. So yeah, I'll just get straight into it. Just a brief kind of rundown of what happened or what gave rise to this case. This case arises out of a August 11th, 2020 motor vehicle accident that occurred on private property at a racetrack gas station. So no citation was given. This case was filed on August 5th of 2022, a few days before the statute of limitation expired in this one. And there, at that point, there was no record of any service being performed or perfected on my client, Mr. Perez. The record shows that Mr. Perez was served on June 16th of 2024. So here we're nearly 2 years removed from the statute of limitations period at that point. Mr. Perez actually, on his own, filed a pro se answer, I believe July 11th of 2024. So he handled that, and his insurance carrier was notified, which then prompted us to be assigned to the case. On May 9th, we filed an answer in the current motion to dismiss this claim on the grounds of the statute of limitations and the doctrine of latches. Since the expiration of the statute of limitations here, there was no indication on the record of any diligent attempts taken by plaintiff to serve Mr. Perez. There's no affidavit of non-service or anything explaining what actions were taken to serve Mr. Perez in this one. And so service here on June 16th of 2024 would not relate back to the time of filing, and plaintiff here would be guilty of latches. There's case law, and specifically, let's see here, Canton v. Justice, where plaintiffs didn't serve a defendant until about 16 days after statute of limitation, and the court dismissed that action, and that was upheld on appeal. Here we have nearly a 2-year delay in service, so not exactly sure what happened here, but it most certainly does not show diligent efforts to try to serve Mr. Perez upon the expiration of the statute of limitations. And so we would ask this court to dismiss this action with prejudice.
All right, Mr. Foster, how does it relate back to that the statute of limitation is told?
Judge, I agree with the argument that it does not relate back. However, it is our position that the answer on July 11th, 2024 waived this defense based upon Euler CX, well, I'll just give you the site, 274 Georgia Appeals 252. It's a 2005 case. And it says matters of personal jurisdiction are supposed to be brought up at the earliest possible time, those defenses. And if not, then they are waived. And so it is our position, Your Honor, that first, that this position has been waived. This defense has been waived, but if the court does not agree with that this has been waived based upon that case that I just cited, I would ask that even the new Georgia rules, Senate Bill, was it 63 or 68?
Yeah, that.
Yeah, that. It has taken away my right. It has basically taken out Hobbs v. Arthur. And I had that right for about a year until the motion was filed and the law was passed. But subsection C allows you to allow me to dismiss and refile. So if you do not believe he was waived, I am asking that you allow me to dismiss and refile.
And briefly, Your Honor, in response to that, we're not asserting any defenses as it relates to personal jurisdiction. We're arguing that this case is barred by the statute of limitations, which is not one of the waivable defenses included in 9-11-12. So we would argue that would not be on point for this issue here today.
And just to kind of put a bow on it, Your Honor, it is somewhat rich that they say I delayed in bringing up in serving, and that's fine, but they delayed in bringing up this motion for 10 months. Had this motion been brought up immediately, I would have been able to avail myself of Hobbs v. Arthur. Now that the Senate bill has taken Hobbs v. Arthur away.
So you said that they waited until the Senate ruled in their favor.
But you know what? I thought about this. Wait a minute. No, that's right.
That's quite the novel argument. Like the legislature is about to come down with this omnibus. We about to all be in the thick of it, tripartite trial, reorganization of everything holy in civil practice, and you think that Mr. Mars is more than just an incidental beneficiary of that. I'm just messing with you, Mr. Foster.
I'm just saying, Judge, would you, based upon that, I'm just asking that you allow me, if you do not buy the argument of waiver, that if you would allow me to dismiss and refile, which is your right under subsection C of the new law.
And I will add just one last thing is that, I mean, there was the opportunity to dismiss involuntarily once defendant was served, but that was not requested until we're here today. So I'll just leave it at that.
And latches was not
everything in this case is a day late and a dollar short, as my grandmother would say. Service was late, filing this motion is allegedly late. Then now you're saying it's late, but I'd like to refile. Everything's a little bit on a delay. It's okay. All right. Did you have anything else for me, Mr. Foster?
That's it, Judge.
All right, Mr. Mars, anything else?
Nothing further to add. Thank you, Your Honor.
All right, we will delve into the new stuff and look at the old stuff, and we're on the cusp of the change, so we will see what is most appropriate and give you an order.
All right.
All right,
sounds
thank you,
good. Thank
Judge.
you, Your Honor.
All right. Thank you, gentlemen. It's been a pleasure.